Trump sued over offshore leasing order. Environmental groups are asking an Alaska court to strike down President Trump's latest executive order, which reverses permanent protections for more than 625 million acres of the Outer Continental Shelf, OCS, opening the door to new offshore oil and gas leasing in the Arctic, Pacific, Atlantic, and Gulf regions. The lawsuit, filed July 8 in the District of Alaska, argues that Trump's order exceeds presidential authority under Section 12A of the Outer Continental Shelf Lands Act, OCSLA, which allows presidents to withdraw federal offshore lands from leasing, but not to reverse prior withdrawals. Environmental advocates say the order would expose fragile ecosystems and frontline communities to seismic surveys, spills, and other risks. This action is not just unlawful, it's dangerous, wrote Eric Grafe, an attorney with Earth Justice in a court filing. These waters support subsistence lifestyles, irreplaceable biodiversity, and a sustainable ocean economy. The law doesn't allow any president to single-handedly undo those protections. Legal déjà vu in Alaska. The case reprises a legal battle from Trump's first term, when his 2017 attempt to revoke President Obama's offshore withdrawals was ruled illegal by the same court in League of Conservation Voters vs. Trump. That case was later mooted when President Biden reinstated the protections in early 2021. The latest lawsuit claims Trump's January 20, 2025 executive order, issued on his first day back in office, violates both the U.S. Constitution's property clause and the clear language of OCSLA. Plaintiffs include the Sierra Club, Oceana, the Natural Resources Defense Council, and Alaska-based organizations such as the Northern Alaska Environmental Center. Biden-era protections in jeopardy. President Biden had used Section 12A to withdraw key regions of the OCS from leasing, citing the environmental, cultural, and economic value of coastal ecosystems. These included the Beaufort Sea in Alaska, the northern Bering Sea, deep-sea canyons in the Atlantic, and habitat for critically endangered species like the Rice's whale in the Gulf of Mexico. Interior already taking steps to lease. Shortly after Trump's order, Interior Secretary Doug Burgum issued 3 directives. Secretarial Order 3420 ordered bureaus to expedite the leasing of the OCS. Secretarial Order 3417 cited a national energy emergency to fast-track oil and gas development. Secretarial Order 3418 directed the agency to suspend and revise the current 2024 to 2029 offshore leasing plan. The Bureau of Ocean Energy Management followed with an April 2025 Federal Register notice announcing a new 5-year leasing program and reopening all 27 planning areas, including those previously withdrawn, for analysis. Legal, environmental, and economic stakes. The complaint highlights imminent risks, especially from seismic surveying, which often precedes leasing by several years. Plaintiffs point to past harm from spills like Deepwater Horizon, as well as disruptions to whales, fish, and coastal economies from industrial noise and activity. Plaintiffs argue that the lack of statutory or constitutional authority for reversing a withdrawal makes this case ripe for resolution, even before lease sales occur. This legal challenge could set a critical precedent on the limits of presidential power over public lands, especially as oil exploration resurges under the energy dominance policy revived in Trump's second term. You've been listening to Sustainability Soundbites from E+E Leader, where the business of sustainability meets real-world impact. Thanks for being a loyal listener. To inquire about brand partnership opportunities, reach out to a member of the E+E Leader team.